Now I request Mr. Vivek Chirania to introduce our chief guest, Advocate Ashish Makhija, President of IPNet.
I think you can skip this part, not required.
It's a small introduction.
Mr. Vivek, please.
Yeah, and I feel privileged to introduce Dr. Ashish Makhija. Advocate Ashish Makhija is a highly respected legal expert and a prominent authority in corporate and insolvency law in India. With over 30 years of experience, he practices before the Honorable Supreme Court of India, various high courts, and the NCLT. His litigation and advisory work span diverse domains with a strong focus on the IBC, company law, contract law, and commercial disputes. Dr. Makhija has represented a wide array of stakeholders in complex insolvency proceedings, including financial creditors, operational creditors, dissolution professionals, and corporate debtors. He is also a prolific author, having penned several authoritative books on IBC, company law, and contract law that are extensively referred to by legal professionals, academicians, and regulators. In addition to his legal practice, Dr. Makhija is a sought-after trainer and speaker. He has conducted professional training programs under the auspices of IBBI, ICAI, ICSI, and judicial academies across the country, earning recognition for his clarity of thought and practical approach. Serving as president of IPNet, a national forum of insolvency professionals, he plays a key role in promoting thought leadership and professional excellence in the field of insolvency law. It's my pleasure to request Makhija sir to share his thoughts on today's topic. Thank you.
Thank you, Vivekji. I think the most important, first of all, friends, a very good afternoon and good evening to all of you. In fact, I would really appreciate the efforts of Mr. Rajiv Agarwal, who is heading the IPNet East, in selecting this topic. In fact, on a lighter scale, before this webinar began, I think one of our central head, Tina Saraswat, she was mentioning, sir, this is a very painful topic. I agree. It is a painful topic. It is a tough topic. But at the end of the day, if we don't discuss, if we don't seek help from others, the pain is not going to subside. So therefore, the pain also needs a treatment, isn't it? So that particular thing is we have to come out in open, discuss the issues, what is happening, what is not happening, what we should do, what we should not do, all those kinds of things. If we need a change in a code of conduct, maybe we can also come out with our suggestions. Or at the end, if how to tackle those cases, I think there are three keynote speakers who are very competent and very thoughtfully selected today. Mr. Dharab, Mr. Pratik, and Dr. Talvinder. I think this is another aspect I would like to mention, friends. That the reason is that all IPNet members are extremely experienced persons. And we are very happy to tell you that during this journey, very short journey of almost around 7-8 months today, we have been able to request people and also sometimes forcibly make them speakers also. That no, you have to come and speak on a particular subject. Now people are coming voluntarily that yes, I would like to speak. And I think the great example is Dr. Tavinder Palji. I think he's a fantastic person. He's very regular in attending all webinars of IPNet. Of course, we are not offering any CP hours, but he still is very regular. And suddenly now he says, yes, I would like to be a faculty. I would like to speak. I think this is exactly what we request all members, because everyone is so experienced. Please convey your assent that yes, you would like to speak on a particular topic. Send it to me or to any of your IPNet representatives. We are looking for newer faculties. We are looking for many other things. Now, let me come to the topic. In fact, being a IPNet president, when Rajiv ji requested me that you be the chief guest, I was slightly shocked and surprised. I said, look, I am the host, right? So we are always the host. So how can I be the chief guest? He said, no, sir, you are not the host. I am the host this time because every week there is a responsibility of a different region. So this time, typically, the responsibility lied with the Eastern region. So anyhow, I'm extremely delighted. I'm extremely honored to address this esteemed gathering today at the IPNet webinar on insights from IBBI disciplinary committee orders. Well, I extend my heartfelt thanks to Mr. Rajiv and his team. And of course, he puts in people from other regions also, like Namrata ji, who is anchoring today. She belongs to Mumbai IPNet, but she is still here. Similarly, Tina ji is also there, who is from Central team. So I think this is something which is a great integration. Friends, today's topic is not just a technical compliance exercise. This topic strikes at the very heart of our credibility as insolvency professionals. Now, the IBBI disciplinary committee orders are not punitive instruments. According to me, they are signposts. They are cautioning us where the line of professional integrity lies. Now, let me begin with a very an important quote and a timeless quote by Benjamin Franklin when he said that it takes many good deeds to build a good reputation, but only one bad one to lose it. So, in the insolvency field, or maybe in any professional field for that matter, reputation is everything. One disciplinary order can actually tarnish a career which is built over decades. So now let's try to look at what exactly we I'm not going into the deeper details because the speakers are already there. I'll just cover broadly. I think everyone is aware about the code of conduct. The code of conduct, according to me, friends, it is not a bureaucratic document to be filed away in a drawer. According to me, it is our compass which can guide our every action, decisions, and communication. So I'll request each one of you, if you have probably you would have gone through the code of conduct, but at the end of the day, I think if you can keep a copy of the code of conduct printed on your table, which you can see and read maybe one part of it because it is divided into 10 parts, read one part on a daily basis. And after the 10th day, on the 11th day, read the first part again. I think the more we read, the more we will be able to form about it. Like what it demands from us broadly, independence and objectivity, not just in form, not in substance, no hidden affiliations, no biases. It demands transparency. It also requires us to be confidential, right? Confidentiality. That is very, very important. And second, lastly, diligence and competence. Timelines are not suggestions. I think many of the IPs are under the belief because of certain NCLT orders, NCLAT orders, or Supreme Court orders. Oh, the timelines mentioned in the regulations are directory and not mandatory. Friends, let me caution you, for IPs, they are mandatory. They are statutory obligations. Delay is not just an inconvenience. In fact, it is a breach of trust. And sometimes it can cause a lot of difficulties for the professionals, insolvency professionals. And I have seen many cases. And in fact, it's very painful when some insolvency professional comes to me and tells me, sir, I have received a show cause notice or an investigation notice or an inspection notice. Well, friends, one more suggestion I can give you. You may be doing your jobs well, but you may receive maybe sometimes an inspection notice, which may be a routine inspection, not based on complaint, maybe an investigation notice, or maybe a show cause notice also. Please take professional help. Do not.
Sir, you are muted, sir. Sir Makte, sir, you are muted.
Sir, you're on mute, sir.
I don't know, maybe somebody muted all. Anyway, okay, I'm audible now.
Yes.
Okay. So all I was saying was that, look, insofar as the cases are there, whenever a show cause notice comes or maybe inspection starts, I know you guys are competent, you can handle it. But please make my advice, take professional help from that day itself. Because you may be too emotional or overburdened with the facts. How it is to be presented before the in a very capable. I'm not saying you need to hide anything. Rather, we have to disclose everything. But how it is to be disclosed, in what form it is to be disclosed, I think that is something which a professional can guide you. It can be your friend, it can be your professional IP, it can be advocate, it can be anyone. Because the people, then they come to me with these kind of show cause notices, it is extremely painful, my dear friends. And I must tell you, though the flow has slowed down a bit, but in one particular month, I got 10 show cause notices from my friends on my table. They landed on my table. It was really, really painful. So, friends, I think this is one of the advice which I can give you. Now, of course, what these IBBI disciplinary orders, which I think the competent speakers will tell you, what we need to learn. We have to learn from others' mistakes. This is the best platform when you read the old disciplinary orders and you know, oh, this mistake was made by this person, so therefore I should not be making that mistake. Now, this is something which is extremely crucial. I think, friends, may I request everyone to just mute themselves so that there are no background noises, because there are some background noises are coming. Thank you so much. So all I'm saying, my dear friends, is this is that we have to learn from others' mistakes. It could be intentional, it could be accidental, it could be anything. So therefore, the importance of these cannot be undermined. So what we have to really take care broadly, conflict of interest. We must see that there is no conflict of interest, because even a perception of bias, iota of a bias, can undo your good work. And timelines, as I mentioned, non-compliance with timelines are taken very seriously by IBBI and also IPAs. Well, those timelines have to be followed. And in fact, the Supreme Court has repeatedly emphasized, in fact, we have seen in Bhushan Power and Steel, a plan which was approved, but it was approved beyond time. In fact, some strictures were passed against the NCLT and they said, oh, how can you approve it outside the time limit? So therefore, time is the essence under the IBC. Of course, that order is under review. Maybe curative petition may also be filed. We don't know what is going to be the fate, but we have an order in hand. So let's understand timelines are extremely crucial. Then, of course, disclosure, transparency and disclosure. This is one parameter, I think, on which the whole system, you see, lies. Otherwise, it will crumble. The confidence which the people have in IPs, I think that cannot be broken, and that can be sustained due transparency and disclosures. So don't be afraid of disclosing, because you are doing everything right. And of course, the misrepresentation cannot be there. So that, because that can trigger disciplinary proceedings in a very, very big manner, my dear friends. Now, one more aspect which I want to just cover very broadly. Of course, the learned speakers are going to take you to all those details. Whenever you get a notice, many people ask me, sir, how do I respond? Right? So the response is, number one, the cooperation. Cooperation is the key. Respond promptly to every notice and request. Do not delay. Do not stonewall. The regulator will definitely value transparency. Two, the second of that advice, which is tip number two, which I can give you, is document everything. And I have always been believing that in any CIRP or liquidation or any insolvent IBC assignment, typically you have to keep a detailed record of every step to whatever you take. That is very important. And because remember one thing, in law, if it is not documented, it did not happen. This is the law. So therefore, documenting everything, creating your minutes in a very careful manner. They are not going to be, even if your team creates it, team drafts it, I request each one of you to please read each and every word, full stops and commas. And whenever you get a notice, seek a legal advice or seek legal counsel or whosoever is able to help you, which can draft you the balanced, factual, and persuasive submissions. I'm not saying you cannot make, but you can make factual submissions. But is it balanced? Is it persuasive? Because submissions have to be persuasive because this is a judicial, quasi-judicial kind of a case, right? And if we have made a mistake, assuming something has gone wrong, you did not publish the notice in time, maybe there is a 1-day delay, acknowledge that mistake. Now, if you demonstrate that, okay, I'm ready to take a corrective action and there is a commitment to improvement, I think that will be taken little sympathetically. and learn from the precedents, as I mentioned to you. What the guy should have done differently, that is very, very important. In fact, I think this gives us an idea, and Rajiv ji can take lead, and other regional heads who are here. I think we should have series of webinars on the disciplinary orders and what mistakes are done. Because you see, in one webinar, we may not be able to gain the entire thing. So anyway, we'll think about it and we'll do some continuous kind of engagement in this particular thing. So, and another important is that as an IP, we don't have to be reactive. We have to be proactive. So the focus should be shifted from firefighting approach to a compliance first mindset. So compliance first, this is very, very important. So how can you do that? Training. Of course, we are attending webinars like this. Yesterday's knowledge is not enough for tomorrow's challenges. So therefore, you need to keep yourself updated. Peer reviews. IPNet forum is there where you meet so many people. Just put it in the chat box. We have created so many study groups. Make them more active. Ask questions. Share best practices. And of course, the standard operating procedures. I think you have already got many of them. At IPNet also, we are working to create more standardization. So this is what is very important. So what is the larger picture, my dear friends? The larger picture is we need to protect the integrity of the profession. Now, every disciplinary order is not a rap on the knuckle of an individual, but it is a reflection on the entire profession. And all of us carry that burden. And of course, also the honor of being the custodians of all the stakeholders. Right? So this is very important, my dear friends. And I remember some few words also. Be more concerned with your character than your reputation, because your character is what you really are, while your reputation is merely what others thinks you are. So by living the code of conduct, my dear friends, we can build both character as well as reputation. So friends, IBBI disciplinary orders are a mirror. They show us where we have faltered. Let us not fear that mirror. Let us embrace it and use it as a tool for growth, for further improvement. And as insolvency professionals, my only suggestions is, and I think I know many of you personally also, let us stand tall. And you have been doing a fantastic job, not as just as resolution expert, but as guardians of the fairness and trust. And I wish each one of you the wisdom to learn from the past, the courage to face future challenges, and the integrity to uphold the trust which has been placed in us. Thank you, and I wish you a very deeply enriching session ahead. Thank you so much.
Thank you so much, sir. This was truly an awakening and it has shaken us up all. And I can see lots of videos on, and I expect all others who still not on, please on your videos. With this, I would just request IP Binay Singhania, sir, to express gratitude on behalf of IPNet. And as Binay, sir,
Yes, yes. Yeah, thank you, Mr. Mata. We are thankful to Ashish Ji to have provided so insight into the role of the IP, and I could gather on whatever he has said is completely clear, but I could gather one line from his speech that IP should be proactive and not reactive. So if we are proactive and we can we continue with the present changes in the law, whatever notices, whatever questions or inspection should be there, or SCN would be there, we would be in a better way to provide everything. So thank you, Ashish ji. Although you are the chief guest here, but we don't have the memento ready for you as of now. But we'll surely be providing you at your address in a very short span of time. But I think with your words, yeah, with your words, all the IP will be getting more and more insight into the IBC law. Thank you, sir.
Thank you, Mr. Bineji. In fact, as IPNet president, I do not require any memento, but I mentioned to Mr. Rajiv Agarwal, he makes beautiful mementos and gives it to the speaker. I said, "एक मुझे sample जरूर दे देना."
We are
Rajiv
delighted.
sir has
Thank you.
confirmed it is reaching you, sir. Rajiv sir
Absolutely.
Thank you, sir.
confirmed it's
Thank you,
reaching you soon.
I would like to keep it as a souvenir in my office. That's all.
Definitely, sir.
Thank you.
Namrata, please
Thank
continue.
you.
Yeah.
Yes, sir.
Over
Sir,
to Mr.
we come to the first lead speaker today. And for that, I would request Mr. Vivek Chirania to introduce the lead speaker of this webinar, Mr. Dhara Prasad. Vivek, sir.
Thank you, Namrata. CA Dhara Prasad Kamlakar is a distinguished chartered accountant and insolvency professional, holding academic and professional credentials, including MCOM, MPhil, FCA, DISA, ICAI, and DIP IFRS from London. With deep-rooted expertise in the insolvency and bankruptcy code, he had effectively led CIRP and liquidation proceedings for several companies, such as Sapphire Hospitals Private Limited, Jejani Pulp Private Limited, and Sridhar Castings Private Limited. His leadership is executing multiple resolution plans, and his strategic advisory role in complex IBC matters reflect his command over insolvency resolution mechanisms. Mr. Dharap has made notable contributions to capacity building under the IBC framework. He co-authored ICAI's publication Do's and Don'ts for IPs and has served as a special invitee on the ICAI's Committee on IBC. As a seasoned faculty member, he has delivered impactful lectures at various ICAI branches, the National Academy of Direct Taxes, and to resolution professionals in the 50th PREC batch. He is impaneled with major financial institutions such as SBI, Bank of Baroda, and Bank of Maharashtra, and has previously served as expert director at the Yavatmal Urban Cooperative Bank Limited. His practical experience, academic contributions, and institutional affiliations make him a highly respectable figure in the field of insolvency and financial restructuring. I request Mr. Dharap as the lead speaker to share his thoughts on today's topic. Thank you.
Thank you, Vivekji, for introducing me. Am I audible?
Yeah, yes, sir.
Yes, sir.
Yeah. I'm thankful to Dr. Ashish Makhija and Rajiv Agrawal for giving me this opportunity through IPNet for presenting today's topic. I require certain help whether my PPT is being displayed properly.
Yeah, let's say it is displayed.
I'm not able to
Yes.
see. Pardon, sir?
It's
PPT
visible,
I have
sir.
shared.
It's visible.
It's visible. Okay.
Yes, sir.
It is moving also, no?
Yeah.
Moment is there because I am not
Yes.
able to see it properly on my laptop. Okay.
Yes.
So friends, today's topic is on insight from either to me in the sense when I started my career as an insolvency professional, I found that the entire ecosystem, including the law, regulations, everything was new and very limited information was available. So we used to take help of the various decisions. And similarly, I started tracking the DC cases also in order to understand that we need to learn from the mistakes of the others. And that is why after a few years, IBBI jointly with our institution asked me to prepare a book, particularly contribute on do's and don'ts. I think the recent edition has still been brought once again. So, what I have done is I have scrutinized the DC cases across and tried to put it in such a format that in which areas the mistakes were conducted, mistakes were done particularly by the IPs. And that is what we can learn from that. that we should not repeat that type of mistakes, because as you are aware that in the initial stages, the code and the regulations were being amended from time to time. Similarly, the mistakes that were initially located were a slightly because of lack of regulation and law, and many a times due to inadvertence. So I would like to tell you that in our times, we had a very big figure in income tax called as Nani Palkhiwala from Mumbai. So he used to be the ultimate authority in income tax. But when I met him and saw him on one occasion, he was carrying his Income Tax Act rules along with him in his bag. So he said that he is reading the act and regulations rules on a daily basis. So friends, that is how we should also do. Whenever a particular Form G is to be published or a public announcement to be made or whatever relating to the professional work we are required to do, just give few minutes, open your code, open your regulations, re-verify all the thing, even if you know that I am aware of that. So what I will humbly request is to revisit so that the mistakes will be less. So basically, the other key speakers, they are going to deliberate upon the other areas. So I am slightly restricting myself to the findings of the DC cases without much mentioning about the penal or punitive action that is taken, and without disclosing the name of the IP, even if it is there available on the website of the IBBI. So a matter is often debated about the suo motu powers of the board. So whether board can conduct the inspection on its own. So friends, the board has been empowered under section 218 to scrutinize or inspect all your records. Similarly, a show cause notice can also be issued without any inspection or investigation that is being carried out. So I think today we have a good speaker, Mr. Advocate Sarkar, who will deliberate upon this. But certain myths and I want to clear. Then I move to the cases. There is one important doctrine of double jeopardy, as you are aware, that we are accountable for two masters. One is the IBBI and another is the IPA, to which we are of which we are a member. So there was only one case, particularly in that case, both IPA and IBBI has taken some action on the same case, but otherwise such things are not repeated. So the nature of actions that were taken was monetary penalty, suspension from practice for a certain period of time. A maximum period of 10 years was noted by me. There might be any case more than that, I don't know. Removal from membership, directions relating to the cost, a combination of above other appropriate penalty as determined by the committee, or in few cases, a warning to be more careful and vigilant in future assignment, which will be then viewed seriously. So friends, as of now, there are about 251 DC cases that has been passed till May 2025. So this was one of the first cases, basically, that IP has given consent for about 15 CIRPs when that IP didn't had any experience, and she and her husband, both were IPs, and they have done a lot of mistakes at that time. And many of you might be knowing, even 4.5 crores of rupees was charged, and that things. So we should see that we are not charging any exorbitant fees. And subsequent to that, basically IBBI came out with the circular of charging the minimum fees. So these type of things are nowadays not repeated. So that was all in the initial period. Now I come to the first part, that is AFA. So friends, there are few cases. Initially, this AFA requirement came in 31st December 2019. So at that time, there were mistakes done by many of our friends and members and colleagues, that without having a valid AFA, they have given consent. So I have found many cases of DC in which they have taken lenient view, or in case of IPA, they were given a penalty of 10,000, 20,000 and so. So AFA, you should be very cautious about. Then next is relating to appointment of valuers. So in a few cases, RP failed to exercise independence in the appointment of valuers. So what happens is, many times regarding the independence of IBBI has come on very heavily, because they don't want that IP to work under the directions of COC in certain cases. So here we should see, we should tactfully deal it with the COC by way of communicating with them, and see that our independence is maintained by way of not creating emails and other things. And we should see that the valuers are properly appointed by us. Now, in another case, it was found that from the various emails exchanged between secured FC, the valuers and the RP, it was evident that there was excessive involvement of FC, and thus RP failed to exercise his independence. That is what has been observed by IBBI. Next, relating to the approval of COC. Friends, there are certain things which we don't have been given entire power as such. We have to exercise certain powers with the help of COC, like RP appointed auditors to conduct the audit of corporate data. However, RP failed to get their fees approved by the COC. Then again, appointment and fee of valuer were not ratified by the COC, though RP contended that he has mailed the quotations received to members of the COC, though inadvertently it was left out to be ratified. So friends, here again, these are the weaknesses, that merely by sending it to the members of COC doesn't serve the purpose. Then it has to be got approved, and that approval also, you can see that nowadays we have voting platforms, or you can use Google Sheets, or you can take a physical sign on the resolutions. So as Makhija sir told, creating documents, creating evidence in order to safeguard our work is very important. Then another was a case where a firm was appointed thrice to perform various functions, while another professional was appointed twice. That is what IBBI has noticed. So these things we should try to avoid. We are free to appoint various professionals for various work. Okay, there was one case of avoidance transactions. So COC requested to carry out forensic audit on 15th of March, and it was appointed on 13th of July. So that was the major delay. And as far as filing of application, the RP further failed to file an application with adjudicating authority. So here also we should be taking enough care, because that 45 days period, then 75 days period to form an opinion. So now in each and every case, we, after having taken the custody of the corporate data, we should see that we are forming an opinion about the PUFE transaction. You keep your observations in writing in your file, and then go for the appointment of auditor or the transaction auditor or the forensic auditor. And upon his finding, there is another thing to be taken care of. Upon receipt of report from the auditor, give the corporate debtor an opportunity to explain those observations. And then based on that, because in some cases, bench has observed that you have merely taken the report and filed an IA. So it is also not expected that we will not go through the report, we will not give them the opportunity to represent. So try to complete the transaction and then do the next work of filing the petition. Then as regards CIRP costs, there were few cases. Yes, any queries in between? Okay. So,
So 20 minutes handled at the last.
so I will continue with my topic, and after I complete it, then I will answer the queries. Okay.
Yes, yes, sir.
Thank you. So cost of the IRP was wrongly billed in the name of CD. So basically the thing is that we are taking the custody. So if ABC Company Limited take the bills as RP IRP ABC Company Limited and book it under the CIRP cost. But apart from that, there were major other issues, like legal counsel was appointed by COC members in the second COC meeting, and it was their legal counsel. The fees was decided in the said COC. So it has been observed that fee of legal counsel of COC was included in the CIRP cost, which was naturally is not required to be included in the CIRP cost. Next was an observation that it was the COC and not RP who decided to conduct the forensic audit second time. The cost of second audit should not have been made a part of CIRP cost. So there was a case in which COC was not satisfied with the forensic audit report, and they decided to conduct the forensic audit once again. So friends, in such case, COC is at a liberty to conduct audit any number of times, but the important thing is we should not include the cost in the CIRP cost. Similarly, in my few occasions, I found that the COC wished to conduct a separate valuation. I asked them that you can take a separate valuation from your panel valuers or whatsoever it may be. I gave them a clear-cut idea that it will not form the part of CIRP cost. You will have to bear the cost. So in such a case, we will not be in trouble. Now, another was a case in which it was the COC, not the RP, who decided to conduct the forensic audit second time, the case which I just discussed right now. That, yes. So not only were properties of guarantors valued at request of COC, but the cost of the same. So this was a case when the properties belonging to the guarantors of the corporate debtor was asked to be valued by the COC, and the problem is it will not form part of the CIRP. So these type of smaller mistakes inadvertently may happen, and that is why we should take care of that. So unnecessary expense that were incurred by the RP in conducting the COC meeting after the completion of CIRP period. So that is also attracted by IBBI. So we can avoid such type of things. Now, a complaint against the RP followed by his arrest. There was a case in which the CBI has arrested that RP. So a complaint was filed on 3rd February against the RP by erstwhile director of the CD, inter alia alleging that the RP has demanded an illegal favor of rupees 2 lakhs, then to extend the CIRP period. One time bribe was also there. So friend, this is a particular typical case. I won't discuss much on this, but such type of things should categorically be nobody. Acha, in that case, I would like to bring your attention that nowadays every call made by you to another person is getting automatically recorded without your knowledge, even though that may or may not be accepted as an evidence. That is a different issue, but call recording is a common thing, and that is why you might have seen that many times this people are calling through WhatsApp. So WhatsApp, according to me till now, that is what I have learned, is a safer option for communication. So these CDs or disgruntled CDs often make you prey of a particular mistake, and that is how they try to blackmail you in that case. So be cautious. Anybody coming to your cabin, any corporate data particularly coming to your cabin, ask him to keep their phone outside, because recordings also do take place, and many times during casual discussions we may not always be cautious enough to speak. So that is what practice we should follow, is ensure that the things are not getting recorded, so that we will not be trapped anywhere. Next is regarding the conflict of interest. So a firm where IP was a partner was appointed for infrastructure and back office support. So this is, friends, in many cases, it is a common type of mistake. We should also see that whosoever we are appointing is no way connected, because in my case, my son is also a chartered accountant. He is also dealing with IP. So in such cases, we should see that no correlation is established. Yes, any query in between? Shall I continue? Rajiv ji?
Sir. So continue, sir.
Yeah. So we should avoid conflict of interest. In no way the services to whom we are appointing should have any relation with us. That is a very important thing. And another case was delay in appointing the forensic auditor. So it was observed that in the minutes of the third COC, COC discussed and approved the appointment of forensic auditor, and it was in the month of November 17, and it was appointed in April 18. So 4-month delay, there is no answer for a delay in appointment, and subsequently the RPA failed to file the application immediately, and it was also submitted after a delay of 4 months. So in this case particularly, we should take care that the POFE transaction I are immediately made. Then there was another case. As per provisional balance sheet, the CD was having a stock of about 27 crores, while the liquidation value of the stock was reported as 6 crores or 7 crores. So RP sought explanation from ex-director on the difference of value of inventories. IBBI observed, DC committee observed that there is no specific provision in the code or regulation which requires seeking such explanation from ex-director. So there was no necessity of calling any explanation. If your 27 crore worth of stock is turning out to be 7 crores from the liquidation value, you can straight away file an application with the IA under section 66 of defrauding the creditors. And in one of my case, which was pertaining to a paper industry, another was a cashew nut industry, cashew processing unit. The stock was in majority written off, and in 8 out of 10 cases, you will find that stocks and debtors are often written off. So why they are written off? Because they are bogusly carried on year basis for obtaining the cash credit limit from the bank before they are turning into NPA. And once the cash credit limit becomes NPA, then this stock which is hypothetically raised, the debtors which are raised are immediately written off. But basically we need to see that in totality, if a stock is written off, then whether there was any insurance. In my paper industry, they said that it was nothing was left. So on the first day when I went to the unit for taking custody, I did a video recording by a professional videographer and take a notice that there was no stock lying at the factory premises. So that is how care you can take. Then mistakes or rather issues were observed relating to the disclosure requirement of IPA. Now you are aware that there are monthly, quarterly, half-yearly, yearly requirements. So naturally, we being IP, we are supported by our team. Prepare them a calendar, ask them to complete the disclosure requirement on a monthly or a quarterly basis, whatsoever it may be, so that such type of things can be avoided. So in a few cases, delay of 8 months was observed, delay of 1 year was observed. And in that case, unnecessarily, you will get yourself penalized. There were in one of the case, 6 months, 1 year. So friend, this is not the delay. This is ignorance of doing the compliance. And nowadays, you can see that because of introduction of AFA, many a times while taking this annual AFA exercise, your entire submissions are verified. Without that, AFA is not granted. And whether you have done all the submissions, whether you have completed the CP hours and all other things are studied simultaneously. Then there was an interesting case when RP has informed the COC member that around 300 trucks of the corporate data were being illegally used by a concern in which there was a stake of the promoters of CD and the entire revenue was credited to this concern's bank account. Further, it was also observed that the promoters of CD have transferred the staff of the CD to its concern. So RP has failed to make any application when he sees such type of fraudulent things taking place. Then as far as the public announcement, though there are very few cases, but the delay in making the public announcement in case of regular CIRP was about 35 days. And in case of voluntary liquidation, it was about 18 months in one case and 8 months in another case. So another delay in disclosure of IP is IRP directed to disclose the fee and other expenses in Form 2 within 7 days of demitting the office of IRP to IPA, which was submitted with 3 months delay. So this is all relating to the compliance. But in one of the case, he disclosed the valuation with the COC without confidentiality undertaking. So the RP discussed the liquidation value, fair value with the member of COC before taking any confidentiality agreement. So friends, that is why, as suggested by Dr. Makija, we need to document it properly so that it cannot be, it cannot come against us. Then certain errors were observed in capturing the creditors, means the claims. So IP made an error in capturing the claims, amounts of 2 creditors, due to which the voting percentage of these creditors were calculated on admitted amounts which were higher than the actual amount. So if such type of mistakes happen, then it becomes very problematic in the sense many times the voting percentage changed during the CRP. So we have to be very cautious because CRP voting percentage, many other things depend on this voting percentage. So in that particular case, the voting percentage got deferred. Next was the case. Actually, a DC proceeding was going against him, and he failed to inform the stakeholders and the adjudicating authority also about the DC proceedings pending against him. So, friends, actually, I have also undergone this DC process in detail. There was a frivolous complaint against me by the CD, and for a period of 3, 4, 6 months, first the inspection took place. I made the compliances of all the inspections. Then the report was given to me. I again offered my explanation on that. Then the show cause notice came. So particularly where it is required is once you receive a show cause notice and till the time it is concluded, till that time you cannot take any assignment, you cannot give any consent. That we should remember with the help of this circular. So in this case, he failed to inform the stakeholders as well as adjudicating authority. Then effective control was not taken of 7 properties. So that also record we need to create because custody and control is a very primary thing which we need to establish. And if we do not take effective steps, it will come against us. Then failed to make public announcement. Yeah, in one of my case also it happened that Cuttack bench appointed me in one case, and I saw that the registered office was in Chhattisgarh. So on the first day, I immediately within 3 days gave an advertisement in Chhattisgarh newspaper. And by the time I could get the data from the corporate debtor, I could come to know that they have another 2 units, one in Karnataka and another in Odisha. So immediately we called for the quotation from advertisement, and probably on the very next day, the advertisement were published in other 2 papers also, means the other 2 states, Karnataka and Odisha. So many times while making the first public announcement, it may so happen that you are not aware of the CD. When the case section 9, again in a section 9 notice, I was appointed. So I was not aware of the CD. So only after collection of data, but immediately after a collection of data, you should do the compliance. That is important thing. Then in the second COC meeting, there is another case when COC resolved to liquidate the CD. This was based on, friends, only the interim valuation report. So even though now it is permitted to liquidate as per the decision of the COC, we should see that all the things are placed before the COC in a proper way. Then avoidance agreement also we have discussed. Failure to follow the moratorium. Yeah, in moratorium particularly, the RP himself took the COC that a particular financial creditor's EMI be continued to be paid during CRP. So it is a direct violation of your moratorium. I don't know how this has happened, but that was the case. And reconstitution of COC, yes. So in case of particularly authorized representative, wherever it is required, we should see that we are taking proper authorization from the adjudicating authority. Otherwise, it will come under the lens of IBBI. So I think I have fairly described the important aspects. But as you can see just now, that the recent Supreme Court judgment which has been given in case of JSW, the level of mistakes even in that such a big case that RP has made relating to the section 12, relating to section 29A, these are all, even the form H has not been submitted, which is required to be submitted along with the resolution plan. So all these things are very important, and we should scrupulously follow all these things. I think I'm falling a little bit short of time. But yes, friends, in case of information memorandum, I would like to tell you that there were certain cases where COC has intimated about certain discrepancy in the information memorandum. That was also not incorporated by the RP. And see, information memorandum is such a document which gives a fair idea about your CD to the prospective resolution applicant. So we should try to include all those that information which is there in the law regarding what are to be what are the inclusions in the information memorandum. So IP is under the obligation to prepare information memorandum. Another thing I would like to bring to your notice that there are certain cases where IBBI has observed that certain duties and responsibilities like taking of custody, verification of claim, preparing information memorandum, then verifying. Nowadays we have agencies to verify 29A also, but regarding the eligibility of the resolution applicant and also the completeness of the resolution plan. So these are the primary duties which we cannot delegate to anyone else, even not an IP or a different IP. So these are the things which directly rest on us, and in many cases it is seen that for infrastructure and back office arrangement, that IP has handed over this task or of verification of claim, preparation of information memorandum. So these are not the separate work, and it is our duty to do it on our own. So information memorandum, lot many mistakes are there. Outsourcing, I have discussed that we cannot outsource certain things, and those which we can outsource are to be categorically outsourced. It should not be built through us. So friends, I will like to stop over here because there are a couple of other speakers who have certain interesting things to be shared with us, including me. So I am thankful for your patience, Siri, and please offer your question answers if any, or even if we can take it at the end of the session, whatever
So
Rajiv Kumar sir permits.
Sir, the question and answer session, we have an allotted time for that at the end of the session. And we're taking
Fine.
all the question
I will
answers
do
rather.
yes.
Thank you. Appreciate that. And there's amazing response, lot of queries in the chat box, but all will be taken up at the end in the question answer session. Thank you so much, sir, for enlightening us. I request now IBBI Singhania, sir, to express gratitude on behalf of IPNet and offer a memento to our lead speaker, IP Dara Prasad, sir. Mr. Binay? Mr. Binay? Binay, sir? Binay, sir?
Ramata, you can continue, no issue. You can give.
Right.
Yeah.
Thank you. Prasad sir for this wonderful session and for sharing all the insights and all the synopsis of all the cases that are relevant to the disciplinary committee. And I'm sure it has told us all that covers as many aspects as you could. We've all got to know where all we have to cope up, where all we have to, see that things don't fall out of our hands. And this has been a really, really, really helpful session to all of us. Appreciate, and this is a certificate of appreciation from IPNet. We're presenting it to you as a lead speaker for today's session. Thank you so much for being today. And it was nice of you that you can stay till the end. We have a lot of questions and a lot of inputs from you further to be taken, sir. Thank you. Appreciate you.
Thank you.
Thank you so much, sir. I would now like to request IP Vivek Charania sir to introduce our first keynote speaker of today, Advocate Prateek Sarkar.
Thank you, Namrata. Advocate Prateek Kumar Sarkar is a dual qualified professional with academic credentials in information technology and law, LLB, bringing a unique blend of the technical acumen and legal insight to his practice. Since 2019, he has been actively practicing law, representing clients before the Supreme Court of India, various high courts, NCLTs, DRTs, and other judicial and quasi-judicial forums. His areas of specialization include IBC, surface matters, regulatory compliance, financial fraud, and dispute resolution. Advocate Sarkar's prior experience with ICICI Bank's legal group enriched his litigation management capabilities, where he was involved in monitoring high-stakes litigation, impaneling legal professionals, and leading nationwide conciliation initiatives that resulted in significant cost efficiencies through out-of-court settlements. He also holds a postgraduate diploma in banking from Manipal University and multiple certifications, including in limited insolvency, currency derivatives, mutual fund distribution, and depository operations. An accomplished legal author, Prateek is proficient in legal drafting, regulatory analysis, litigation strategy, negotiation, and standardizing legal processes. His interdisciplinary approach and practical experience makes him a well-regarded professional in the domains of banking, finance, and insolvency law. I request Mr. Sarkar as the keynote speaker to share his thoughts on today's topic. Thank you.
Thank you, Vivek ji. At the outset, I thank Rajiv ji and Dr. Makhija Saab for giving me this opportunity to address on today's topic. Is my screen visible, sir? Is my screen visible, sir?
Yes, yes, sir.
Yes,
Yes,
thank you.
visible.
Thank you. Now, as Dr. Makhija Saab said, that we must be proactive. Now, if a notice comes, a notice of investigation comes, then what are the things that we can do to safeguard ourselves? That aspects I'll be covering now. Now, I have divided these aspects into 4 broad heads. First is the safeguards in IBC when an insolvency professional is faced with a show cause notice. The second is safeguards through RTI, which an insolvency professional can avail when he or she is facing with a notice of investigation from IBBI. Safeguards when an adverse orders are passed by NCLT against an insolvency professional in terms of referring his or her conduct to IBBI, and safeguards during the discipline committee hearing. Now, there is a key judgment and very underutilized judgment in the domain of IBC laws, and that is in the Dharani Sugars Chemical Sources Union of India, wherein para 55 of the said ruling says that if a statute confers an authority with certain powers to do a particular act, then that has to be done in that particular method only. And it necessarily prohibits doing that same act in other manner. Now, why I'm saying this aspect? Many times, and even in the comments I was reading, that many technical infractions are, as a result of many technical infractions, insolvency professionals are getting punished. So there we need to go to the source of power that is being sought to be used against us in disciplinary mechanisms. Now, I had the opportunity to represent in this matter before Honorable Bombay High Court, and I'm quoting the extracts from it. Now, there I had divided the insolvency order into the series of events which culminate into the passing of that order. I'm reading the exact extracts that before any show cause notice is issued, under section 219, first, the investigating authority has to be appointed under section 218. Then that authority has to file its report to IBBI. And then after considering that report, if IBBI is convinced, then a disciplinary committee is appointed under section 220 of IBC. Now, there are three things that are coming out. First, there has to be an investigation order. Second, that investigating authority constituted of that order must present a report. Then a show cause notice gets issued. And after that, a disciplinary committee proceedings under section 220 gets initiated. Now, what are the contents of that order under section 218 that has been specified under regulation 7 of IBBI inspection and investigation regulations? That provides for, now I'm reading sub-regulation 2. By an order, direct an investigating authority to conduct an investigation of the affairs of the service provider and to report thereon to the board. Sub-regulation 3. The order referred to in sub-regulation 2 shall contain the following particulars. And these are the particulars that are listed. The point that I'm trying to emphasize is just a file noting, just a passing remark cannot substitute an order under regulation 7. An order under regulation 7 read with section 218 has to contain these mandatory particulars. After that, the investigating authority then submits a report to the board under regulation 10. Under regulation 11, the board considers that report and then forms an opinion that whether there exists a sufficient cause to take action against section 220. The point that I'm trying to emphasize is that if there are technical infractions, these reports are very important as to ascertain that what is going through the mind of the discipline committee or the investigating authority or the board, so as to warrant that an order under section 220 needs to be passed against me. Because technical infractions, frivolous complaints, that can get finished right at the stage of regulation 10. It doesn't have to go to regulation 11 or regulation 12, rather a show cause notice in simple words. Now, the show cause notice, and this is also an important aspect when we are agitating against technical infractions. When a show cause notice is issued to us under regulation 12(1), how we are benefiting out of it? What are the evidences that are against us in support of that show cause notice? That has to be categorically brought to our notice. And that's a mandatory requirement of regulation 12 sub-regulation 1. And the IBBI or the show cause notice, we are duty bound to have it. It is our right for us to contest the allegations or the charges in the show cause notice. Second, regulation 12 sub-regulation 2 says that the show cause notice must say that what is the advantage that I have gained out of the alleged contravention. Second, what is the loss that has been caused to the stakeholders or any other person as a result of that alleged contravention. Third, what is my conduct? My means the insolvency professional's conduct post, prior to, and subsequent to the alleged contraventions. These factors have to be considered by IBBI before issuance of a show cause notice. Now, here there was an order by Honorable Delhi High Court in the matter of Manish Kumar Gupta versus Discipline Committee IBBI, which says that the material basis which the show cause notice is to be issued, that has to be given to the noticee. And IBBI and 5 orders of IBBI Disciplinary Committee were reported back to IBBI for another set of hearing after supplying the noticee of the papers and the materials. And there IBBI, the Honorable Delhi High Court had analyzed this, that by regulation you are duty bound. I'm not going into the question whether it is directory or mandatory. You have to give it for the noticee to contest the charges laid out in the show cause notice. It is not just IBC. When I'm contesting a discipline committee hearing, Honorable Guwahati High Court in the matter of Kailash Jalan versus State of Assam had categorically stated that the adjudicating authority, in our case in IBBI Disciplinary Committee, must disclose all the material placed before it and must be given reasonable opportunity to the affected interest to submit his or their case. A fair hearing means that a person against whom an adverse order is passed should be informed of the charges against him, giving him opportunity to submit his explanation to the charges, and the person is also have a right to know the material on the basis of which the allegation is proposed to be decided. What I'm trying to emphasize is that I cannot project my imagination to fill in the deficiency in the investigation report. An ordinary person who is having a knowledge of IBC should be able to connect with the charges of the show cause notice along with the material. And there cannot be a conjectures and surmises to frame out the charges. This is what the mandate of Honorable Delhi High Court in Manish Gupta's case is. This is the mandate of Honorable Guwahati High Court in Kailash Jalan case is. So we are entitled by law to get each and every document which has been provided in the regulations as a matter of right for us to contest the charges in the show cause notice. Through this, technical infractions, frivolous complaints, all can be curtailed to a very extent. Now, the major point is, now quite often IBBI comes up with a response that we have to maintain confidentiality, and that's what IBBI regulation says. And here RTI Act comes to our rescue. RTI Act is very categorical that a public information officer has all the information which every public servant is entitled to have. And the information basis the regulation that I have quoted, these are public information. So if not in the capacity of an insolvency professional, then as a capacity as the citizen of India under Article 19, I am entitled to have all copies of those documents under RTI Act, basis which the show cause notice has been issued to me. I'm reading para 13 of Honorable Jammu and Kashmir High Court ruling in the matter of Tyndall Bisco School. So far as the definition of information given in section 2F of RTI Act is concerned, it means any information in any form, including records, documents, memos, emails, etc., including information relating to any private body which can be accessed by a public authority under law for the time being in force, that has to be given. And this is the definition of provided under section 2F that is being explained by the Honorable Jammu and Kashmir High Court. So we have two mechanisms. First, under IBC as per Manish Gupta judgment. Second, as per RTI under Tyndall Bisco School judgment. We are duty bound to be provided with this because I have to contest. I cannot project my imagination into what is going through the mind of IBBI. And also the 12(2) regulations, the factors has to be considered in that show cause notice. If those factors are not listed out in the show cause notice, that is not a show cause notice as per section 219 of IBC, as per the ruling in the matter of Dharini Sugars, the Taylor v. Taylor principles that I started with. Now, what if an NCLT passes an adverse observations against it? Now, many a times I have seen in the discipline committee order, cognizance are taken of the adverse observations by NCLT, and those orders are simply forwarded to the insolvency professional, and then he is asked to contest the findings of that. At that time, even in that situation, the mandatory requirements of the regulation cannot be done away with. And here comes the Honorable NCLAT ruling in the matter of Ilamchand Kamboj versus ENG Industries. Para 3. Normally, the adjudicating authority is not supposed to pass any adverse observations, even prima facie, against the resolution professional without giving an opportunity to the resolution professional as to why, in view of a certain act, the matter be not referred to IBBI. Now, for example, there might be worst of worst conduct which has been brought to the attention of NCLT, but I have at least one opportunity to present my material so as to say that, look, the observation, the prima facie view that is sought to be created against me, that is wrong, and hence at least I have one level of opportunity to contest that. If that is not granted, and para 5, Honorable NCLAT has said IBBI cannot treat the observations as made by the adjudicating authority as referred to above as the final decision against the appellant, as the observation made without granting opportunity to the appellant. Therefore, IBBI will hear the proceedings and decide on merit after hearing the resolution professional and taking into consideration reply as may be submitted by the appellant, uninfluenced by the observations made by the adjudicating authority. So it is not the case that the observations of adjudicating authority are a prima facie good enough presumption to hold adversely against me. Even if an order has been passed, then also the tests laid out under Regulation 7, the test laid out in Regulation 10, 11, 12, all of them have to be followed and all of that material needs to be supplied to me so as to give a reasonable opportunity to have an informed opinion to contest the findings against me. Now, many a times I have seen many stray comments, many casual statements are made across the bar, and then an adverse observations have been passed against insolvency professionals, and IBBI has taken cognizance of them and then said that no, you have to satisfy there is a prima facie observation, the presumption is lies against you, so now you have to contest that. Now, here is a judgment in the matter of Honorable Supreme Court in the matter of Ayub Khan Nur Khan Pathan versus State of Maharashtra, which relied upon the Honorable Supreme Court ruling in the matter of Needle versus Needle. Now, this Needle versus Needle is a ruling passed in Companies Act 1956. And that is categorically stating that it is generally unsatisfactory to record a finding involving grave consequences with respect to person on the basis of affidavits and documents alone, without asking that person to submit to cross-examination. The point that I'm trying to emphasize is wildest of the wild allegations can be made against an insolvency professional. But before referring that conduct to IBBI, there should be at least one stage of cross-examination which the deponent of those adverse observations has to go through. If that is not gone through, then the presumption is the deposition against me, the adverse comments against me cannot be read in evidence at all. Now, the provision for that cross-examination is provided in NCLT Rules 2016, wherein it says that notwithstanding contained in Subrule 1, where the tribunal considers it necessary in the interest of natural justice, it may order cross-examination of any deponent on the points of conflict, either through information and communication technology facilities such as video conferencing or otherwise as may be decided by the tribunal. If wild comments are being made against me, I have a right for at least one level of cross-examination to establish even prima facie that what is being said is not correct. It's a misinterpretation of the material. Rather, I am being falsely quoted and an adverse impression is being held against me. So to sum up my discussion, first, I am entitled by law to contest my show cause notice, to have every document which is being used against me. I cannot project my imagination to fill in the gaps in the investigation. There cannot be any adverse opinion basis conjectures and surmises. Second, even if NCLT passes any adverse observations against me, as per the Ilam Chand Kanboj ruling, IBBI cannot be influenced by that, and IBBI has to make its independent opinion. Third, the person making wild allegations against me, the insolvency professional, he has to undergo the test of cross-examination, and the enabling power provision of that is Rule 39(2) of NCLT rules. Now, having everything said and done, what is the recourse that can be taken to the disciplinary committee during the course of disciplinary committee hearing? Now, if there are procedural legal infirmities in the process adopted in initiation of disciplinary committee proceedings, we are entitled by law to present that before IBBI, to say to IBBI that, look, the very law under which you are proceeding against me, these are the provisions which do not allow you to. First, you clear that, and then certainly I'm open to it. And this is not a stonewalling tactic. Rather, this is presenting the law as a defense that, look, your action is conflicting the Honorable Supreme Court ruling in the matter of Dharini Sugars, the Taylor and Taylor principles, which is required to be followed in any proceedings under IBC. Now here I'm quoting, I had the benefit of representing Sri Vakati Reddy in this matter. And these are the observations of IBBI in the said disciplinary committee order. Mr. Vakati Balasubramaniam Reddy, in his response to the show cause notice and also during the proceedings of personal hearing, has raised certain preliminary objections on the procedure leading to issuance of the show cause notice. He has challenged Regulation 7, 10, 11, and 12 of inspection and investigation regulations have not been followed. Further, he has challenged that Regulation 7 of IBBI grievance and complaint handling procedure regulations has not been followed. Now, even I'm pausing here for a moment. Even Regulation 7 of IBBI grievance and complaint handling procedure regulation says that when a complaint has been received by an insolvency professional, IBBI has to apply its mind as to whether the complaint is frivolous or not, or whether the infraction is so fatal as to initiate disciplinary proceedings against the insolvency professional. It cannot be the case that a complaint against an insolvency professional is being directly sent and the IBBI and the insolvency professional is left guessing as to what he has to contest because he has no clue of what is going through the mind of IBBI. Now, reading further, if the initial action is not in consonance with law, all subsequent and consequential proceedings will fall through. Now, if Regulation 7 is not complied, if Regulation 10 is not compliant, if there is no application of mind in terms of formation of opinion that whether there exist situations to issue a disciplinary committee order under Section 220 IBC, the show cause notice is vitiated at the root in law and all subsequent and consequential actions would fall through. In the circumstances, in the matter of Sri Vakati Reddy, the DC concurred with me and said that before going into the merits of allegations made in the show cause notice, it is important to address the preliminary submissions regarding the procedures being not followed before the issuance of SCN as raised by Mr. Vakati Balasubramaniam Reddy. After considering the submissions of Mr. Vakati Balasubramaniam Reddy that the principles of natural justice have not been followed, the DC deems it fit to refer back the matter to the board for re-examination of the complaint in accordance with the provisions of applicable regulations. Now, IBBI in this matter did not iterate a single point on the charge of the show cause notice. IBBI simply stated that, look, if the regulations leading up to the issuance of the show cause notice has not been followed, sorry, I'm not going into that. I'm reverting back the show cause notice to IBBI for reconsideration. Now, one of the underutilized provisions which an insolvency professional has is provided under Section 233 of IBC. I'm reading it for convenience verbatim. No suit, prosecution, or other legal proceeding shall lie against the government or any officer of the government or chairperson, members, officer, or other employee of the board or an insolvency professional or liquidator for anything which is done or intended to be done in good faith under this code or rules or regulations made thereunder. Sir, the point that I'm trying to emphasize is, if given the situation, I have done something wrong, so please tell me, in my situation, had there been someone else with that material, what decision contrary to what I have made could have been made? It's not that a hindsight information is taken to be held against me. And this is the protection under good faith that has been provided under Section 233 of IBC. The bottom line that I'm trying to emphasize is the very law under which an insolvency professional is proceeded against, that very law has given adequate safeguards for the insolvency professionals to defend himself in terms of materials. And if IBC in any form is deficient, we have enough avenues under RTI Act to bring in all materials to contest ourselves in the show cause notice. Thank you.
Thank you so much, Advocate Pratik sir. With this, we move on to the next session. I request Mr. Vivek Chirania to kindly introduce our keynote speaker for the webinar, Dr. Devinder Pal Singh Arora, sir.
Sure, Namrata. Dr. Tevinder Pal Singh Arora is a seasoned professional with over 47 years of diverse experience spanning engineering, valuation, safety consultancy, and insolvency. He holds multiple qualifications, including a PhD in mechanical engineering, BE Honors, ME Research, GIE from NITIE Mumbai, MA in political science, diploma in business management, and B music in tabla. A government-approved registered valuer and insolvency professional under IBBI, Dr. Arora specializes in valuing plant and machinery, real estate, vehicles, and inventories for banks, NCLT, mergers and public sector undertakings like MSTC, HUDCO, BALCO, and CWC. He is also a chartered engineer, independent director, insurance surveyor, arbitrator, ICA life member, and certified safety consultant recognized by the Labor Department of MP and CG. He has led valuation assignments exceeding rupees 2,000 crore for clients such as JPL, JSPL, NTPC, CSPGCL, and Bhilai Steel Plant. Currently director of 3V Pro Appraisers Private Limited, he has authored numerous research papers and is a fellow life member of several professional bodies. His contributions have earned him prestigious awards, including the Lifetime Achievement Award, Institution of Valuers, Dr. Meghnath Saha Award, and the Hall of Fame Award from USA. It's my pleasure to request Dr. Arora as the keynote speaker to share his thoughts on today's topic. Thank you.
Yeah. I'm audible, sir? Am
Yes,
I
sir.
audible?
Yes, yes,
Yes, sir.
Good evening, everyone. Thank you so much for introducing me. At the outset, I would like to thank Ashish Makhija sir, Rajiv Agrawal sir, and all the team members, and my co-speakers Dharab Prasad ji and Advocate Pratik Sarkar, who have delivered wonderful, the insights from the IBBI Disciplinary Committee orders. They both had the different scenarios, like Dharab Prakash sir he didn't speak even the name of a single IP or RP who suffered from this, and that was a very nice of him. Actually, we thought that we will not name them, but if you are discussing some practical case, you may have to name something. Even Pratik Sarkarji was also saying that RTI is a very good tool, for the future. So that also he has taken care of a lot, and he has done a good job. We have discussed previously also. So, sir, actually, when I start, and this is the first time I am speaking in front of so many learned CAs, IPs, and advocates and people, of a lot of caliber. I didn't have a chance to be an IP, practicing IP. So, but anyway, I have an interest of learning the things. So I am doing best of my sir. इसको इधर ला सकते हैं।
Sir, Arora, you can continue.
When we talk about IPs and the problems they have faced because of silly mistakes, there are certain sections which are very important. We have discussed. I'll just tell you the section 196, subsection Q, 217, 280, 220, 250, maybe 207, 208 also, and 240 also. They are very important sections. And then the various regulations are there. Maybe grievance and complaint handling procedure is there, and the inspection and investigation is there. And then ultimately the show cause notice comes and the DC comes into picture. So these things are there. This we have discussed a lot about it. So I will not take anything. I'll go. If somebody is talking, please mute
Yes,
yourself.
request everyone to please mute themselves.
So I would like to go to straightway to the the IPs which who have faced some problem because of the DC orders. So the first case I am going to talk to is Pawan Kumar Bitwajika. He is IP. This order was dated 5th of September 2023. Here the problem was that he has charged the excess fee as a liquidator. It was noted that the liquidation processes of CD 1, 2, and 3, they three were initiated, and it was noted that by the email to 20 March 2021, the board has pointed out incorrect percentage applied by Mr. IP or RP, whosoever is there, for calculation of his fee as a liquidator, and had brought to his notice excess fee drawn charged in the liquidation process of CD 1, 2, and 3. Now the problem was that he admitted now because the excess drawn or calculated fee will be reimbursed and adjusted by him in the net of receivables from each of the companies into the account of the respective company in the liquidation. This was what the liquidator had told the board for that. But then it was seen that it was admitted by the liquidator that he has charged excess fee from, and the regulation 4.3 of the liquidation, it says that the for first 6 months there is a certain percentage of the fee is to be charged. So he further admitted that he of having refunded the excess fees from being pointed out by the board. But then he has refunded the fee, but then what the charges were there. The board noted that the regulation 4.2 of the liquidation regulation 2016 provides for a manner of calculation of fees of the liquidator in cases where same is not decided by the COC. Liquidator is to charge fee in accordance with the manner prescribed by the regulations. The period of first 6 months prescribed in regulation 4 of the liquidation regulation commences from the date of the liquidation commencement date. And this was a mistake here. The set period of the first 6 months cannot be interpreted as the to commence from the date of realization of the asset of the CD. So this was a mistake. The the first 6 months were to be taken from the LCD, which was wrongly taken from the date of realization of the assets. Now, the board held that the Vishal Pawan Kumar failed to read Regulation 4 properly and erroneously took a view that the period of first 6 months will commence from the date of realization of the assets. It clearly evidences Mr. Bidwajka lack of understanding of the provisions of the code and regulations made hereunder. Now, you see, the first and foremost thing what an IP, RP or liquidator, he has to follow the code of conduct and the regulations. We, as is pointed out by all the learned speakers, including Ashish Makhija sir, that we have to read and read several times every word of code to interpret what is to be done. Like I was just attending one more Zoom meeting. There it was. They were discussing about the new forms to be filled up now. CIRP 1, 2, they are replaced by the other forms, and but then there were so many questions were there, but every answer was there in the circular, in the regulation. So when it was read properly, the answer came from there. So if we read the code and the regulations properly, the answers are already there. Might be sometimes the clarification is required, which board is taking care of in the due course of time. May the liquidator had sought pardon for misunderstanding and wrong interpretation for the provisions, and further is sure to conduct himself in the strict compliance of the rules and regulations governing the code of conduct in all his future endeavors. The board imposed him a penalty of rupees 1 lakh. Here, this was a case where the penalty was imposed only, and Mr. Vishal and Vishal Pawan Kumar was directed to deposit the penalty amount directly to CFI, Consolidated Fund of India, under the head penalty imposed by the IBBI within 45 days from the date of the issue of the order, and submit a copy of the transaction receipt to IBBI. Now, then a warning was given to be careful and diligent and strictly comply with the provisions of the code and regulations. So had he read the, regulation 4.2 of the liquidation regulations 2016, this mistake must not have been done, that he has charged the extra fee for which he had to suffer so much. Now, again, the same rules and regulations are there, that they were connected here. I am going to, discuss another case, which is the matter of Vishwanath Rajgopalan. This is the latest order in the IBBI website. This was done on the 15th May 2025. Now, here the commencement of CIRP was 18/4/2023. Consent obtained from IPs to act as IR is 23rd day, 22 plus 1. There's a gap of lapse of 22 days, 23rd day. Emails to Home Buyers Association for appointment of AR is 25th day. So like that, this chart is there. So what the lapses were there? There was a delay in every of the acts taken by the RP. So here I'll come to the here the basically 6 contraventions he made in the single case. So many contraventions are there. So I think this itself is going to take a lot of time, whatever time is I am given with. So this is there was a case where he was appointed as IRP, and then he was replaced with another RP. So there was a time lapse. He delayed every activities. Then a show cause notice was given following all the procedure. Like he was given firstly an investigation was done. Depending upon that, the show cause notice was given, and then he replied to the show cause notice, and he made written submissions. The DC finds Mr. Vishwanath had failed to perform his duties provided under the code, read with regulations made thereunder. The DCs of the view that Mr. Vishwanath made the following contraventions of the code and regulations made thereunder. The first contravention which was seen was delay in the appointment of the authorized representative for the home buyers and consequential exclusion of the home buyers from the voting in the meeting of the COC, exclusion of the home buyers. So these were the 2 allegations. One is the delay in the appointment of AR, and second was the exclusion of certain home buyers for voting in the meeting of the COC. Now, Regulation 16A2 of the IBBI insolvency of CIRP provides that the IRP shall apply to the AA for appointment of the AR selected under sub-regulation 1 within 2 days of verification of the claims. Means 21 days are there, 14 plus 7, and 23rd day he should do it. Received under sub-regulation 1 of the regulation 12. Further, as per regulation 40A of the CIRP regulation, the AR should be appointed within 23rd day from the insolvency commencement date. So now here there was a delay of the appointment of AR for about 2 months. Mr. Vishwanathan had contravened regulation 16A2 of CIRP regulation, regulation 72A and 72H of IBBI IP regulations, read with clause 14 of the code of conduct as specified in the first schedule of the IP regulations. These contraventions were made by the IP there, by the IRP there. Now regulation 2A, I just point out the regulation 2A says the registration shall be subject to the condition that the insolvency professional shall at all times abide by the code, rules, regulations, and guidelines thereunder and bylaws of the IPA with which he is enrolled. And 728 says that they should abide by the code of conduct specified in the first schedule of these regulations. And clause 14 of code of conduct IP regulation will say where the board is of the opinion that sufficient cause exists for the recognition of an IP entity, it may do so by passing a reasoned order. These are the regulations which were referred here for him. So this was the contravention 1 which he has done. There is a delay in the appointment of AR for about 2 months. Then the second contravention was that the status of the resolution not properly disclosed in the voting sheet of the second meeting of the COC. Now, here, as per the section
Mr. Arora?
27. Yes, sir.
Mr. Arora, I have a request. I have a request actually.
Yes.
We should not take the name of the IP, I think. Rather, we can read only contravention and the action taken by the IBBI.
Okay. Okay, no problem. I'll try to make it that way. Right,
Please,
sir?
sir, please.
Okay.
Sir,
As per section. Yes.
we'll have to enter in the Q&A session, question and answer session. So let us know if you can enter into it
Okay.
if you
Then
can
I'll
conclude.
see.
No, sir, you can conclude. You can conclude. You can close your this. Thereafter, we can
Okay,
enter the Q&A.
Okay, I'll tell only the contraventions which were made, and then briefly
Yes.
within 2 minutes I'll do it and then conclude it. Okay. The contravention
Okay, thank
2,
you.
I told you. The contravention 3rd was failure to include the agenda for the appointment of the registered valuers, which was again discussed that they are to be appointed within 7 days or within 47 days from the CIRP date. So it is there. There was a contravention for that. Then the contravention 4 was circulation of incorrect minutes and failure to address and stakeholders' concerns. And 5th was failure to convene the requisition meeting and causing delay in conducting the CIRP. And then the last one was issuance of the invitation of expression of interest form G without the requisite approval from the COC. So these were the contravention. The other cases which I had thought of sharing with you is where the penalty plus warning was there, and then where no FA was there, the suspension of registration was there for 4 years, and next was the suspension of registration only. So these were the few cases where I wanted to discuss, but looking to the short of time, I thank you very much, everyone from IPNet family, that you have given me an opportunity to speak on this topic. I am highly obliged. Thank you very much. Thank you so much.
Thank you so much, sir. Your blessing and your webinar today has been really, truly insightful. And we're now leading to the question and answer session. Binay Singhania, sir, please take over for the question and answer session.
Yeah, thank you, sir, for giving a brief on what is going on in the disciplinary actions. I opened the session for the participant to raise any query to the speakers, and they can also name the speaker from whom they are asking the query. The session is open.
May I?
Yeah, please, Mr. Ahmed.
Sir, yeah, myself, Hemant Mehta.
Yeah, sir.
Sir, there was a issue as appointment of AR is casting the vote, the disciplinary, action taken to IPs who has not appointed the AR in time. This is in respect of that question. Often it happened that the AR's appointment are already decided, by the RP, but it is going to NCLT, Honorable NCLT, for approval, and which takes about more than sometime 4 to 6 months for appointment of AR, and sometime it may happen that the AR is appointed and the final voting casting for resolution plan is under process. So how to deal with this kind of situation where AR is already appointed, and as per the regulation, the home bias voting will be casted only with the AR's voting. So how to deal with this situation?
Yeah,
I'll take this.
yeah, please go ahead.
Yes, I'll take this. Sir, the thing is that the process cannot stop. So here in this situation, in case if we are fearing any adverse consequences from IBBI or NCLT, the year 233 can come to the rescue. And we can assertively say that the timelines, the CIRP process could never have stopped under any circumstances. I have duly filed my application. Now, if the delays in adjudication on the part of NCLT is taking place. And now I'm not getting into the reason. I could not have stopped the CIRP. Hence, I am entitled to protection under Section 233, and the CIRP is entitled to continue as per there is a Latin maxim which is actus curiam eminent gravit, which says that act of the court cannot prejudice anyone, and that includes CIRP. Sir, if the process is transparent, there is nothing in the court from stopping you in going ahead.
Yeah, thank you, Mr. Pradeep.
Meanwhile, see, one of the notice which has been received by the resolution professional was that in spite of the order of appointment of an AR was in the say 10 COC, and you have already allowed the AR to remain present in the CO from the first COC onwards. So why you have already allowed him without any proper appointment? And
The question,
secondly, why
yes,
why the amount has been paid to him as an AR?
the question is
for his
that
attendance?
if the application for appointment was filed way back, and there is a presumption, if the application for his appointment was filed way back, at least you cannot blame my conduct. Due to absence of AR, I cannot hold up the CIRP. Plain and simple. If the court is not covering an aspect, I have to go by the objectives of the court, that is time-bound resolution for maximization of value of assets.
Because I am
To this,
talking about the
to add,
practical show cause notice which has been received by RP.
Sir, this 233 is
Manner.
good enough. Yes, sir. Sorry.
I would like to add something to Pratik Sarkar, like in case of constitution of COC, which is done within the first month. Once I have prepared the report for constitution of COC and has submitted it, then we are presuming that COC is constituted for all legal purposes, and we continue the process.
And actually, sir, when we apply,
Yes, sir.
we
The RP was also under the same impression, and therefore only he has allowed the AR to be present in the meeting.
The AR is, you have taken
That
the
is the
voting.
233 is the remedy for that.
You
Okay,
selected one
another
and
thing I would like to add from my side, that in all DC cases, as such, we don't have any remedy that is open. Like in case of IPA, they have a remedy to go to NCLAT against the order of IBBI. But for IPs, if the DC, we feel like the order is not proper, we don't have any remedy. And the only remedy that is available is the writ petition. Apart from that, we cannot go to NCLAT or Supreme Court.
Right.
Another instance I forgot to discuss, that at times, sometimes we are, I can say, pressurized by the COC or CD for doing certain things which we should not have done. In one of my case, when they were expecting something different from my side, I asked them to better choose another IP. I will resign and you appoint another RP. So that was practically done by me in my case. So that is also another way of going out if you don't want to deviate from the law. Yes,
Sir, if I may conclude on this point.
Yes, Sarkar, sir. Yes, sir.
Yes, if I may conclude on this point, there is nothing wrong in telling NCLT that, look, given the situation that I was in at the time of taking the decision for which I am blamed today, there is nothing wrong in stepping into my shoes and presenting as per law that what else should I have done. Because as section 60 subsection 5, which is the one of the most used sections in IBC, it says that NCLT is vested with jurisdiction to decide law and facts. So it's not that you can park aside the fact and decide only on law and say that, Mr. RP, you have done wrong. So there's nothing wrong in saying to NCLT that you step into my shoes and tell me what wrong have I done.
Okay, thank you, sir.
Thank you. So I think the main reason for disciplinary in most of the cases we have seen, this regarding once the IP is conducting his own business, and with the condition that whatever outcome would come for the city, that should be in the best outcome should be there. And once NCLT decides the matter against the RP or the liquidator, only after that, this IBBI comes into picture, and they issue a show cause notice. They do not issue a show cause notice in regular matter, means in most of the cases what we have seen. So once we are conducting our work in the light of the CRP or liquidation process, only after, yeah. So what can be.
Sir, I had one query. So if I may ask that.
Yeah.
Yeah.
No, sir, I was going to, I don't exactly recollect, but there was one order, one DC order where the RP was also charged on the ground that he had held some of the COC meetings from the premises of the financial creditor, who was a bank, in that matter, sir. So, like as Mr. As our advocate friend was also saying, that there has to be intent which has to be shown, that there was some uh, malafide intent or something wrongdoing in that matter. So still I see that a lot of these RPs are continue to conduct these meetings from, say, the premises of the financial creditors, which are mostly the banks and PSU banks and all. We just wanted a little bit of a clarity on this matter.
If I may answer that, during such situation, Regulation 12, Sub-Regulation 2 comes to the rescue. That even if I have done it, what is the loss or damage which has been caused to the stakeholder? That is the question. If the loss has not been caused to any stakeholder, the show cause notice is making groundless charges. Plain and simple.
Sure, thank you.
Yeah, Mr. Sarkar, sir, I have one question.
Yes, sir.
Yeah.
See, I'm just narrating facts. See, some cases I also observed where the NCLTs are passing some observations against the particular IP, and the ultimate objective of the NCLT is to pass the order in the application which he has filed. But they are in the same order, they are passing some remarks or something on the order itself, which lead to some conclusion that IBBI may step in, even though in the order itself, throughout the order, the particular RP is not given any chance to just contest those questions. So before going to that merits of the question, the NCLT has not followed any process or due process of the law. So in that case, is whether the IBBI will simply put in by taking the observation in the order.
Generally, on many disciplinary committee orders, IBBI has exactly done that. But here the remedy that are in two phases. First is the IBBI and second is the NCLT. Now, there is a very underutilized provision of 424 of Companies Act, which gives an enabling provision for the NCLT to file an application and summon the documents basis which adverse observations have been made against him, against us, the IP. And 424 has been amended to incorporate the jurisdiction of IBC as well. So if any adverse observations has been made against you, which is just mere oral statement, and generally people of my tribe do, the advocates do make oral statements, and adverse observations are often passed. You are entitled in law to file an application under section 424 subsection 2 read with section 424 subsection 4 and also seek a recall of that order, because groundless observations is as good as a fraud, and fraud is a very good ground to seek recall of the order. And till the time that order,
Whether the NCLT can review their orders, I think it requires appeal before the NCLAT to set
no,
a order.
there is a difference between appreciation of the merits and fraud. 5-judge Constitution Bench of Honorable NCLAT has said that if there is a fraud, then the NCLT is having the jurisdiction for recall. If it is a merit, then understandably the appeal provision is there. Now, right now it is 6 in the evening. Now, if I say it is 6 in the morning and basis that the order gets passed, certainly that is an aspect of fraud. And basis that the application can be filed. But if it is 6 p.m. right now, and basis considering 6 p.m. an order gets passed, then that is the subject matter of appeal.
So a
Because
question to
appeal,
Mr. Sarkar. Sorry.
yes, sir. Yeah,
Sir,
because appeal
what,
is only on the merits. But
sir, what
fraud
do,
or 424 is on the facts of the case. Recall is on the facts of the case. Yes, sir.
sir, what
Mr.
do a
Parasram,
IP
that
do?
would be the last
Yes,
question for today.
yes, sir. So
Mr.
what do a
Parasram,
IP
that will be
do?
the last question.
Yeah. What do a IP do if the CUC is not approving a transaction audit? How do he perform his duties?
At that time, 60 subsection 5 is the best thing. Again, tell to NCLT that, look, this is the situation. What should I do next? Simple. And if NCLT is holding over it for whatever reason, at best we can file a writ jurisdiction before the Honorable High Court to seek directions to NCLT to adjudicate this part.
Yeah, before we can conclude, I would like to bring to the notice of all my professional colleagues and friends that even if you come across such type of show cause notice, you should not come across. But if you happen to face that, there is one last opportunity which is given by the disciplinary committee of you appearing in person in front of them, either physically or through electronic mode. So please avail that facility. It makes a lot of difference that you are defending and presenting, maybe along with your advocate or maybe on yourself. But that makes a difference. So that is the last opportunity which everyone should avail.
Yeah,
Thank you so much, sir. Mr. Binay, please give the concluding remarks.
Yeah. So we are thankful to Mr. Pratik Sarkar, who has deliberated in a very nice manner, and also Mr. Dr. Tarvinder Pal Singh Arora, due to their insight into the Disciplinary Action Committee orders. Our fraternity has gone against many, and the gist is we should abide by the law as soon as far as possible. The best thing would be to record everything, so that any disciplinary action is there, so we can go ahead with second. So I am presenting memento to Mr. Pratik Sarkar. Kindly accept this memento, and of course to Mr. Tarvinder Pal Singh Arora also. We are presenting the memento in the digital form, and we are also assuring you that in a very short span of time, within a week or so, the memento in physical will be getting in your office. So with these remarks, I conclude our
Binay, Mr. Binay.
Forwarding
Please,
to Mr. Rajiv Agarwal for vote of thanks.
Mr. Binay?
Yeah.
Yes. Mr. Binay, before we conclude, we have to thank our moderator, our very own Binay sir. So we just have to share a memento from Binay sir as well. You can just give me a second. Rajiv sir, we are presenting this to Binay sir as the moderator for today for the fantastic moderation. Thank you so much and appreciate all your effort. And Rajiv sir, we will get this delivered to you as well, Binay sir. Thank you.
Definitely.
Now, I would request IPNet Central, Mrs. Tina Saraswat Pandey, ma'am, to make the announcement for the next webinar of IPNet.
Thank you, Namrata. Am I audible?
Yeah.
Yes. Perfect.
All IPNet members, there is a special webinar alert. There is a special webinar on Monday, 16 June 2025, at 5 p.m. We are calling you all to mark your calendars for an unmissable event. Next Saturday, sir, we are not hosting any webinar, any regular webinar. There is a special webinar on Monday, 16 June 2025 at 5 p.m. Trust us when we say it is something big, something is really big coming to redefine the way you think, the way you work. Note the change of date and time, Monday, 16 June 2025, 5 p.m. Don't risk missing out on the game-changing experience. Set your reminders, clear your schedules, and be ready to join us. We promise you will want to be amongst the first to witness what is in the store. Stay tuned, stay curious, and get ready for the transformative experience. Thank you.
Thank you so much, Tina ma'am. And now I request our IPNet East, Mr. Rajiv Agarwal, sir, to please present the memento to CAIP Dara Prasad. Sir, once. Sir, you're on mute.
No, I'm there. Yeah. Thank you. Thank you.
Thanks a lot, sir. Your deliberation will help a lot. This is the digital certificate of registration is given from out of us, and we will surely deliver the physical copy as soon as possible. Thank you, sir.
Thank you.
Over to Rajiv, sir, for the vote of thanks, sir.
Thank you, Romita. Good evening, everyone. It's a great honor and privilege to deliver the vote of thanks on this memorable occasion. On behalf of the organizing team and the entire IPNet community, I extend heartfelt gratitude to all who contributed to make today's webinar a grand success. First and foremost, our sincere thanks to esteemed lead speaker, Mr. Dara Prasad, and our two distinguished keynote speakers, Advocate Pratik Sekar and Dr. Kavinder Pal Singh Arora. Your thought-provoking insights and deep perspectives have great enriched this platform. We are deeply grateful for the clarity, depth, and inspiration your session have offered. A special note of gratitude to our chief guest and IPNet president, Mr. Ashish Makhija sir. Your address on the insights from IBBI Disciplinary Committee orders was both enlightening and thought-provoking. Your visionary leadership continues to be a guiding force for all of us. We also thank Mr. Vinay Singhania, today's moderator, for his structured moderation and valuable observations. Your intellectual contribution added substantial depth to the proceedings. Our appreciation to Ms. Namrata Randevi, our anchor, for conducting the session with grace and energy. You brought an energy and inclusive spirit to the webinar. A big thank you to the transition team and the technical support team for ensuring a smooth, glitch-free experience behind the screen. And finally, to our valued participants, your presence, thoughtful questions, and active engagements made this session truly meaningful. This event is not just a webinar, but a step forward in our journey of continuous learning, deeper collaboration, and collective excellence in the field of insolvency practice. Thank you once again. Thank you, all of you.